rise. The Court of Appeals Division 1 is now in session.
Please be seated. Thank you for being here today. We're here in our case 1 CA SA150125. It's Harris versus Brang, holding real party interest. Each side will have 20 minutes to make their argument, and a petitioner, he may reserve any portion of that for rebuttal as you wish, but you have to watch your time on the clock yourself. The argument today will be videotaped and audio taped, and in a day or two it will be on YouTube, so you can be YouTube stars. We've read the papers and we've conferenced the case, so we're familiar with the facts and the law. So if you want to just launch into your argument, please do so. And because we are recording this, please identify yourself and your client when you begin. Petitioner?
Thank you. May it please the court. My name is Linda Pollack, an Assistant Attorney General representing the petitioners in this action, the Arizona Game and Fish Department and the Arizona Game and Fish Commission, and its director, Mr. Larry Voiles. I won't reiterate the points made in the state's brief. We are maintaining the position that the county attorney and the attorney general cannot both prosecute and defend the commission and the department in state court civil actions under the Title 17 Arizona Game and Fish Code.
Why not? Why couldn't they simply have concurrent authority?
That is the position of the respondent judge and the real parties of interest in this matter, Your Honor. But it was quite clear by 1935 in the Supreme Court decision of Crane versus Frohmiller, where the court reviewed the powers of the Attorney General and declared that the exclusive right to conduct litigation on behalf of the state belongs to the Attorney General himself.
Well, but there have been legislative developments since then, and I don't know that the respondent judge exactly took the position that I just asked you about. I mean, otherwise his order would have been different. I mean, why couldn't the Attorney General and the county attorney and the department simply confer and decide who's going to conduct the representation, given that there are arguable grants of authority to each agency in the statutes?
I would respectfully not agree with that argument. There's no doubt that the county attorneys were charged with representing the department and the commission in 1929. That statute was enacted in a very different time for a very different purpose. As I pointed out in the brief, the 1929 Game Code, the state game warden under the 1929 Game Code had statewide responsibilities to protect and manage wildlife with essentially no staff and no significant budget from the legislature.
Sounds like today.
Well, good point.
I mean, there are budgetary constraints that agencies face these days, and I guess when I ask why there can't be concurrent authority, I'm not suggesting that if there is, you lose. I'm wondering why it's essential to your position to take the position that only the Attorney General can do this. As long as the Attorney General can do it, isn't that good enough?
No, I would submit not. First of all, the Arizona Game and Fish Department has statewide responsibilities for the management of game and the preservation of wildlife and wildlife habitat. It would not serve the needs of this department to have county attorneys whose jurisdiction, frankly, ends at the county line, and who are otherwise occupied with their own respective responsibilities to the boards of supervisors and county officials to be tasked with this responsibility.
But counsel, if the situation is as you suggest, factually, wouldn't the county attorneys then defer to the AG saying, hey, this, we're only dealing with county matters, you have a statewide issue, so we think you should go to the AG. And if there's concurrent jurisdiction, the AG can handle that. And then isn't everybody happy?
That sounds logical, because if you want to harmonize the statutes, that's the way it would be done.
Isn't that what we're supposed to do?
Yes,
if we can.
Yes, if you can.
So, forgive me. You said that you could read them that way if we wanted to harmonize them.
If you wanted to harmonize them, but
Isn't that what we should be doing?
generally, yes. But where the statutes govern the same subject matter and they cannot possibly be given effect without creating an absurd result, then the Supreme Court stated in the Ducey case of a few years ago that a finding of an implied repeal or as a later amendment by the legislature is required.
But
now
ma'am, I'm sorry, but you just said it's a reasonable way to interpret the statutes that they can be harmonized.
Well, no, we're saying that they cannot be harmonized. For example, it is not reasonable to have two sets of government attorneys represent the same state agency in the same matter. You cannot have a situation where the Game and Fish Department receives legal services and legal advice on pending litigation, and then the case must be then handed off to the county attorney for the prosecution of that case, especially when the county attorney is unfamiliar with the department's laws, missions, and policies.
Isn't that, maybe the analogy will seem too distant, but isn't that what happens in every single criminal appeal?
Well, that's a good point. The county attorneys are charged under 11-532 with prosecuting all public offenses in the name of the state in the courts. However, at the point where a criminal case prosecuted by the county attorney is appealed to the Court of Appeals or to the Arizona Supreme Court, the county attorney is then charged with sending the case to the Attorney General, who by law,
Yes.
Although in some cases, the Attorney General represents the state in the trial court in criminal cases, and in some fairly rare matters, the county attorney appears at the appellate level. The two bodies seem to have their responsibilities fairly well delineated, and I'm not suggesting this is exactly analogous to a criminal case, but the notion that they can't work together seems belied by everyday practice.
The county attorneys can invite the participation of the Attorney General in criminal cases if the situation requires it. When I was at the county attorney's office in Yavapai County, I asked the Attorney General for assistance on a complex mine fraud case. So that can happen. I'm unfamiliar with the county attorneys, in the appellate courts.
Well, special actions do happen, but
Right.
Here, let me just. I'm just looking for the site here. Under 41193A, isn't there sort of express authority granted for the county attorney and the Attorney General to work together? A2.
May I turn to the statute?
Yeah, sure. It's A2 and A5.
I need to find it. It's 49-192,
193.
193, excuse me. Is it A3?
A2.
A2.
Or A5, actually.
Okay, at the direction of the governor or when deemed necessary, assist the county attorney in the discharge of the county attorney's duties.
So here...
And that happens, I mean, in criminal cases. However, I'm not aware of any situation where the Attorney General called upon the county attorney to discharge his obligation to give legal advice to state agencies or to represent the state in state courts. You know, the reason I don't believe these two laws can be harmonized is because the legislature has passed many specific statutes governing the Attorney General's role towards state agencies and the state agencies' duty to be represented by the Attorney General unless specifically exempted by the legislature. I would respectfully direct this court's attention to ARS 41-192D. That is, I think, the clearest expression of the legislature's intent that, with the exception of 10 enumerated state agencies who are allowed to hire their own counsel, state
Counsel,
agencies are...
Let me jump in there. Isn't
Yes.
that what the primary concern is here for the Attorney General's office, is that the AG's office would be disqualified and not be able to give advice, and potentially either the county attorney or some private attorney would step in? Isn't that your main concern?
Well,
I mean, is the county attorney asking to get involved in this case, to start representing these state agencies?
absolutely not.
I mean, I was a former county attorney, too. I can guess that never happens.
It has never happened. And, you know, in my... This has been...
Well, then if we harmonize the statutes to say that there is concurrent jurisdiction, so to speak, a game and fish can be represented by the county attorney or by the AG, don't you win?
Well,
Doesn't, if that it would be a holding, wouldn't Judge Brain's ruling be wrong and that you would win, and then you could advise and represent game and fish?
well, but then the question, then it becomes perhaps a tug of war. What if the Attorney General does not want to give the case to the county attorney?
Well, do we have that here? Can't we let that wait for a case where the county attorney is demanding to represent game and fish? You gave excellent reasons why no county attorney would want to represent game and fish.
Correct.
So I understand the theoretical problem that you're perceiving, but I don't see how it's an actual problem.
Well, you know, I would assume that in every instance the county attorney would be happy to delegate, you know, the game and fish litigation back to the state of Arizona. But that's not guaranteed. That is not guaranteed at all.
That's not the issue before us. The issue before us is whether the Attorney General's issue was properly disqualified in this one case.
Right.
There is no action before us asking for a resolution of the relative powers of the Attorney General's office, which is represented today, and the various county attorneys, none of whom have even been asked to participate. Are you not asking for a much broader holding than this case requires?
I am. I am asking this court to reverse, you know, the order of the respondent judge disqualifying our office from representing our own client.
In this case?
In this case.
And shouldn't that be what you're happy with?
beg your pardon?
Shouldn't that be what the Attorney General would be happy with?
Of course, we need to get back into the case to represent our client.
I mean, if we were to hold the way you are asking us to, shouldn't we have some participation by the county attorney?
You know, the judge's order was forwarded to the county attorney's office, and although this is outside the record, the chief civil deputy of the county attorney's office called me and was most anxious to give the case back to our office.
Then doesn't that indicate there is no actual conflict here in the way that if we harmonize the statutes in this way?
But the point, our position is that the conflict exists because the legislature in numerous subsequent enactments to Title 41 and even Title 11 clearly indicated their intent that state agencies are to be represented exclusively by the Attorney General's office. And allow me, if you would, to give a few examples. For example, in 1953, the legislature directed self-supporting agencies like the Arizona Game and Fish Department to pay for the services rendered by the Attorney General through a funds transfer. And as you know, I attached that interagency service agreement into the record. The Attorney General's, the Game and Fish Department pays our office $417,000 this year for legal services. The legislature in 1972 authorized only the Attorney General to settle suits against the state. That raises a question. If the county attorney were to handle one of the game and fish cases, who is the opposing party supposed to negotiate with? The county attorney or the Attorney General, who has the exclusive power to settle the suit?
If that ever came to be a problem, that might be a good question to ask then. But it seems that this is a special action, and the only reason for jurisdiction really is that there's no appellate remedy from a disqualification that would be effective. So in this special action, our scope of review is very, very limited. And I think asking for an advisory opinion about the relative powers of an agency that isn't even here may be a little ambitious for today. When the only real question is, can the AG's office proceed to represent the department in this case or not? Judge Brain said no, and it seems that the AG's only legitimate position on special action is to ask us to say yes.
But if Judge Brain is saying no, his opinion is that there is no provision of law anywhere that allows the Attorney General to represent the Arizona Game and Fish Department. If it's concurrent jurisdiction, why was I preemptorily disqualified?
Well, we're not in the questions that we're asking you. We're not channeling Judge Brain's decision.
Right.
We're suggesting that there might be a more modest holding.
That would be in the favor of the Attorney General.
Correct. If Judge Brain had said there's concurrent authority and therefore I'm disqualifying the Attorney General's office, that would be reversible simply as an error of logic.
Right.
We wouldn't even need to resolve a legal question. But he didn't say that.
His opinion, as I read it, indicated that the Attorney General had the sole authority to represent the Arizona Game and Fish Department and Commission in this action.
The county attorney.
The county attorney, excuse me, I misspoke. The county attorney, the sole authority.
And he may well be wrong about that, but the result of that error is not that the converse is necessarily true. That the Attorney General has the sole authority.
And even if you are correct, shouldn't that await a different day, a different case where this court would need to decide that issue? The court doesn't need to decide that the AG has the sole authority.
Well, I don't think it was ever the intention of the legislature that any state agency be represented by the county attorney in civil matters. I would submit that, the legislature, the county attorneys only have such powers as is granted to them by the legislature. And in 11-532, in 2010, the legislature authorized the county attorneys to enter into agreements with other counties or other political subdivisions to provide civil legal services to those other entities, and to define the manner in which the county attorney would be paid and the scope of the representation. The legislature did not, although it could have, grant the county attorney the authority to represent a state agency, but that's not in the law at all, because state agencies are not political subdivisions.
Well, it is in the law, though. I mean, that's the whole problem. There is a statute that says the county attorney shall do this.
Right.
It is absolutely in the law, and the legislature has not expressly repealed that law.
They have not.
So,
Although, if you look at 41-192 subsection D, that prefatory phrase, notwithstanding any law to the contrary, no state agency shall employ other legal counsel or incur costs. Those are the agencies that are obligated to be represented by the Attorney General.
that's a funding provision.
Well, it's more, I would submit to you, Your Honor, that it's more than a funding provision. It's another way of expressing that state agencies, who aren't one of the 10 enumerated exemptions, are to be represented by the Attorney General. And the funding bar, it was the legislature's way of prohibiting them from even trying.
The county attorney may very well have no incentive whatsoever to take up a case like this, but I'm not sure that subsection D tells the county attorney that it can't. I mean, if the county attorney wants to represent the department, and the department, for whatever reason, in a specific case, wants the county attorney, and is going to do it for free, does that violate subsection D?
I would argue yes, because it's an employment relationship.
Council, your time is up, and we've been in an exceptionally hot bench, I think. So we'll allow you 2 minutes for rebuttal if you wish to take that.
Good morning, Your Honor. Judge Howe, Judge Gold, Judge Swan, Thomas Baker. I represent the real parties in interest. I agree with a lot of the comments I heard from the bench this morning, but I disagree with the method of harmonizing the statutes that you suggest. I think ARS 17-103 is a single sentence statute directly on point, stating that the county attorneys are charged with representing the defendants in the underlying case. I think that from what I've heard this morning and what Judge Bain suggested to the AG's office in the trial court proceedings is just go to the county attorney, get a delegation. If the county attorney doesn't want to represent, get the delegation, and problem solved.
Well, why should they even have to do that, though? I mean, is there any doubt that in a statute passed after the Title 17 provision on which you rely, that the legislature expressed a clear intent that the Attorney General's office have the authority to represent every state agency?
No, because I suggest that 41-193, as the court pointed out, states that unless otherwise provided by law, and then it gives the A5 example, that when deemed necessary at the direction of the governor to assist the county attorney. So the county attorney, either through a delegation or an agreement for assistance, still remains the primary responsible attorney pursuant to 17103.
But again, nobody has asked the county attorney, has anybody even served the county attorney with a copy of the special action? They may be generally aware of it, but nobody's asked their participation. And Game and Fish isn't here saying, we want the county attorney. I mean, isn't there some significance to the fact that the AG's office and Game and Fish have decided that the AG's office will represent the agency?
Well, I think if that's their position, it's a simple remedy. Go to the legislature and say, look, you have this statute 17103, stating that the county attorney shall represent the department in civil cases. Would you please change the statute?
But it doesn't say only the county attorney shall represent. It just says the county attorney, I mean, as I read it, the county attorney can't refuse to represent the department, but it doesn't give them that sole authority.
Well, it says each county attorney shall prosecute and defend on behalf of the state. I don't see where it provides for any other agency except through delegation.
Well, that takes away discretion on the part of the county attorneys, but it doesn't mean that there isn't authority for, I mean, what if we had right next to each other two provisions? One said the county attorney shall represent the Department of Game and Fish, and then subsection B said the attorney general shall represent the Department of Game and Fish. I mean, that's not so far from what we have, that they're just spread out among multiple books.
Well, in that case, it would be unlikely to have that scenario, but let's say it existed, how would you harmonize
I think
them?
that's why we're here today, right?
Well,
And if to alter the hypothetical, what if A was in the county attorney shall represent Game and Fish, B says the attorney general may represent Game and Fish.
Sure.
That means the AG doesn't have to, but if the Game and Fish wants, the AG can.
well, I think those arguments can be made to the legislature, and the legislature could change it. But when the legislature enacted,
Isn't that what we have here, though, between the Title 17 statute and the Title 41 statute?
well, the Title 41 says unless otherwise provided by law. So the legislature must have been aware that there are other laws out there that they chose not to repeal at the time they created the Department of Law and the Attorney General's office, or they wouldn't have prefaced that statute that way. And that shows clear intent, unless otherwise provided by law, that they're aware of other laws and they're not repealing them.
They're aware that the county attorney is required to represent Game and Fish if Game and Fish wants, but that doesn't mean that they can, that has to be the way.
Well, I'd respectfully take issue that it's not a may statute, it's a shall. And if they want to change the shall to a may, you just go to the legislature and ask them to do so, not to this court. Their remedy, if they want to change the statute, this very specific statute as to representing them in a civil lawsuit, go to the legislature and get it done. Don't come to this court and try to harmonize them with joint jurisdiction. You can harmonize
That's
it.
what we're here for, isn't it? I mean, both sides in this case seem to be asking us to simply ignore a provision in the statutes, and that's not really what we're here to do. To the extent they can be read together, we have to read them together.
I understand, and that's why I said I disagree with the method of harmonizing them. We're not saying the AG can't be their legal advisor, can't advise them on policy issues, can't advise them as a agency. But we're saying when it comes to criminal prosecution or civil litigation, this ARS 17103 has been on the books.
Why wouldn't we simply say that under 192A5, the Attorney General has apparently deemed it necessary to assist the county attorney, and the county attorney apparently doesn't have any interest in representing the department in this case, so the assistance is all-encompassing.
Well, that doesn't need a court order, it just needs a delegation, which apparently the AG's representative has stated they're willing to give. I mean, We could have gotten that done months ago.
Well, no. I didn't mean that the AG gives a delegation. I mean that to the extent the county attorney requires assistance in performing its duties, the AG is providing that assistance. It just happens to be very broad assistance.
Well, we don't know. Unfortunately, and you see in the brief, the correspondence, right off the bat, I initially requested the AG's office to answer those 3 questions in my response. Have you notified the county attorney? Have they given you a delegation? Judge Brain did the same thing. Have you notified the county attorney? Have you received a delegation? Apparently they had, and they just didn't get the delegation.
Well, but the delegation is a concept that doesn't appear in the statute. That's sort of shorthand that we're using here. As I read the statute, it's not up to the county attorney to delegate authority to the attorney general. To the extent that these provisions exist concurrently, the attorney general may deem it necessary to assist the county attorney, whether the county attorney likes it or not.
Well, I'm not sure it's the AG's responsibility to make that decision. The statute's unclear on who determines whether the county attorney needs assistance.
Well, I mean, clearly, one person who can make that determination is the governor.
Absolutely, that's
I'm
in the
assuming
statute.
He hasn't gotten involved in this case.
Yes.
And
Then it just says, or when deemed necessary, but doesn't say by whom.
well, so your reading of that is that only the county attorney may deem it necessary?
Yes, because 17103, which is the starting point, says it's his responsibility, his duty to represent the department, the commission, and civil litigation.
We know one thing. We know that the legislature by 193A5 intended that there would be times when the attorney general and the county attorney could work together.
I don't dispute that.
Okay. So why should the attorney general be disqualified in this case?
Because the county attorney hasn't requested assistance from the AG's office.
But with all due respect to your client, isn't that really, if it's anybody's concern, isn't that the department's concern?
Well, if it wasn't for 17103 stating they shall, that's...
But the department,
that's,
we've acknowledged that the AG and the county attorney can work together.
I would assume so. Apparently not here, or would have a delegation.
Well, the statute says that the attorney general can assist the county attorney. If the client agency isn't here saying, we demand that the county attorney perform its statutory function and give us the representation to which we're entitled, what standing does your client have to object to an agency's choice of counsel among agencies who have statutory grants of authority?
Well, I think 17103 is clear on its face that the...
But that doesn't go to standing. My question is what standing does your client have to object to a decision that the AG and the department have made internally?
Well, it's contrary to statute.
But as far as your client's prosecution, it doesn't matter to your client whether the county attorney prosecutes a case or whether the AG prosecutes a case. In either case, your clients are being prosecuted. And I don't know. I understand there's, public interest in having the law properly followed, but as far as the prosecution of your clients, your clients really don't care as a practical matter whether the county attorney is at the table or if the AG is at the table.
Well, in this matter, when you say that my attorneys are being prosecuted, I think what you really mean is that the agency, the party defendant, is being represented by the AG's office in this civil case. And I think we have 2 reasons for that. 1, it's contrary to statute, as you just mentioned. And 2, we don't want a potential error coming up following an adverse judgment against them, that they would raise 17103 as a defense to a judgment.
I think it's safe to say they've waived that.
Well, we don't know. But here, when you have a statute, I mean, you can't just ask us to turn a blind eye. It's an issue that needs to be resolved when we're faced with a very, very specific statute enacted by the legislature that has not been repealed. And the basis for the AG's representation clearly states unless otherwise provided by law. That's why I say their remedy is twofold here. One, get a delegation. Two, go to the legislature, bring this to their attention, and say, do you want to repeal or modify 17103? And give them the reasons to do so.
It would certainly be helpful if the legislature had made its intent clearer. It strikes me that the legislature probably had two different intents at two different times. But I mean, in that, at one point, it was absolutely clear that the legislature wanted the county attorneys to do this. At another point, a later point, it's absolutely clear that the legislature wanted the attorney general to do this. But it's what is not clear is that the legislature chose one position over the other versus simply choosing both positions.
Well, what's clear in 1953, when the AG states that 41193 was enacted, that the legislature enacted it by stating unless otherwise provided by law. And we also know that twice since 1953, both in 56 and 58, 17103 as it currently exists was renumbered. So during that time period, 53 to 58, it's hard to say the legislature wasn't aware of 17103 in its current form. And they specifically
But if
stated.
they were aware of it
Yeah.
and felt therefore that it needed to be addressed, wouldn't they have addressed it?
Well, I think they did when they said unless otherwise provided by law.
But that unless otherwise provided by law applies really more to an exception than to the grant of authority.
Well, the Department of Law was created. They listed its powers and duties, and they said, okay, unless otherwise provided by law, the Department of Law shall, mandatory language, and then list the items that it shall do. So I think if they wanted the AG's office to have exclusive authority over the items it listed, it wouldn't have stated unless otherwise provided by law.
Okay.
Any other questions?
No.
Thank you.
Thank you, counsel. Counsel?
Yeah, just a few brief remarks. The legislature has charged our office to be the chief legal advisor of all the departments of the state and to render such legal services as those departments require. Where the department and the commission require our office, pursuant to our interagency service agreement, to appear on their behalf and to prosecute or defend the department and the commission in a state court action, it seems illogical that we then have to turn to our client and say, well, yes, but first we have to get a delegation agreement from the county attorney. That's not what the legislature intended at all.
What if hypothetically your client came to you and said, in this case, we love you guys, but we'd rather have the county attorney do this because there's a county attorney there who really knows this type of fish, and we think they have expertise that would help us.
And our response would be, you're not authorized to go to the county attorney, and that's
At that point, you have a conflict with your client, and some outside counsel has to be retained. Might that not be the county attorney?
no. I think that the conflict is not with the client. The conflict is with the law as it currently stands.
You would tell your client agency, you must use our services.
Yes, absolutely. That would be the
Client agency would then have the right to come here and ask for a determination as to that dispute.
Correct.
And
I
so you would be
suppose,
representing them and on the other side of the room at the same time.
well, if they wanted to do that, then of course, we would have a real issue. But it doesn't work in real practice for both the county attorney and the attorney general to represent a state agency such as the Game and Fish Department.
But counsel, even if that kind of conflict would arise in a hypothetical situation, that's not what we have here, correct? There is no actual conflict in that the county attorney isn't telling your client only we can represent Game and Fish, UAG, go away.
Right.
No one's saying that, so we wouldn't have to resolve that particular problem.
And that's true. In this particular case, there's agreement, that the county attorney wants nothing to do with this particular appeal. But that may not, there may not be such an agreement or a meeting of the minds in future cases.
And shouldn't we await a future case then?
Right. So, again, our position is that the legislature never intended this result. They fully intended the Attorney General to handle all aspects of the litigation needs of the Arizona Game and Fish Department, and that intention is expressed in several statutes, throughout Title 41, describing the powers and duties of the Attorney General.
Thank you, counsel. We appreciate your arguments. We'll take this matter under advisement and issue a decision in due course. And